Good evening. This is Laws 11057, Introduction to Law. It's week number 4 in the Term 3 course for 2014. Tonight's talk will be dealing with legal thinking, and it's based around the New Lawyer chapters 8 and 11. Chapters 8 and 11 deal with some concepts in relation to effectively how we go about thinking about a lawyer and the theory of law. Thinking skills is very important, and the way in which you go about developing your thought processes and reducing that to writing or developing that through verbal argument is critical to being a successful lawyer. I'm just going to recount some of my day today. I won't pretend it's a typical day. It was quite extraordinary, but it did touch upon issues to do with thinking skills and critical thinking as a lawyer. So in today, I actually had the honour of having breakfast with the Federal Minister for Justice, Michael Keenan, and sat next to him. He was in Hervey Bay for the day, and he was here to talk about issues to do with crime and issues to do with justice generally. So I had the benefit of having the audience of the Minister, Federal Minister, for a little while, and I raised with the Federal Minister issues in relation to a matter which is topical at the moment, and that is a review of laws relating to child pornography, accessing child pornography, and dealing with those sorts of issues at a federal level. Now, it's federal because it's a matter of dealing with the Telecommunications Act, and that's all covered in federal law through the Constitution, which provides the federal government with power to make decisions and make laws in relation to telecommunications. So that's why this particular branch of criminal law is federal law. And if you haven't already had a look at the Constitution to determine those issues, I would recommend that you do so. So that was the discussion I had. One issue that I did raise with the Minister was the question of separation of powers and mandatory sentencing. Never a popular topic for politicians generally. There is essentially a conflict of ideas here between politicians and lawyers to some degree, and it's easy for lawyers or politicians or both to, in a way, follow the party line, if I can call it that. So as a lawyer, in my capacity today as president of the District Law Association, my comment was that I'm concerned about the potential introduction of mandatory sentencing in the Commonwealth legislative regime, particularly in relation to those issues. And part of my argument was that it intrudes on the separation of powers. The Minister took a different view and said there is not an issue with separation of powers with the introduction of mandatory sentencing, because Parliament has the power to make the law, Parliament makes the law, and the courts and lawyers must therefore follow the law. So there's no separation. The concern with that, and the issue that I raised, was that a key part of sentencing is the whole exercise of judicial discretion. And in that regard, judicial officers, judges and magistrates are able to take into account a whole range of factors that goes over and above those factors which are simply recorded in the legislation. And we talked about that last week and the weeks before, how it's not, in my view, possible for Parliament to make laws that deal with all issues in a particular area, because there are so many different factors that come into play. And even if we implement issues of delegated legislation, as we talked about last week, to allow members of the executive to make regulations to deal with those multitude of circumstances, we're still not going to cover everything. So the problem, in my view, with mandatory sentencing is that it gives no allowance for judicial discretion. It cannot possibly cater for every particular circumstance that may come before it, and therefore there may be injustices. So the example that I raised with the Minister today was a situation where, for example, a 17-year-old, who in the eyes of our criminal law is an adult, may go onto an internet site, one that he shouldn't be looking at, and it may have been fleeting, it may have been when he or she probably he was affected by alcohol or maybe some drugs, so judgment was impaired. Maybe he has an intellectual impairment, and maybe it was something very brief. So is it fair in those circumstances, for example, for someone to mandatorily, if that's a word, spend time in prison? So my discussions with the minister were along those lines, and it was very interesting. So that was the first part of my day, and then the second part of the day was actually being involved in a trial in the district court before Her Honour Judge Clare, and it was the first day of the trial, but the third attempt we'd had at this particular trial. The first one was a mistrial because there was a hung jury. The second one was there was a mistrial because we had a juror that ultimately was the subject of, if you like, an application to be discharged, and that was successful after the trial began, so we had to abandon that trial. So it was the third attempt today. And what made it really interesting is that contained in amongst the potential jurors was my wife, who had been called up to do jury duty and was unsuccessful in her attempt to extract herself from jury duty on the basis that, she's married to me. How could she possibly be impartial? Anyway, at an administrative executive level, the decision was made that she must proceed. So that's where talk about the separation of powers. So at the executive level, the admin level, the decision was made that she must proceed. Anyway, we just got before the trial, and of course I disclosed this. In fact, I disclosed it last night. And the discussion between defence and prosecution, which was half in jest but half serious, was to the effect, who's going to protest? Now, the idea about protesting in the formal sense is using up one of your challenges. So in a jury trial, you have 8 challenges. So defence counsel can say challenge, prosecution can say stand by, and if that happens, that potential juror who's walking up to take the oath is not going to be on the jury panel. And you want to guard your challenges in case you have someone that you really don't want on the jury. You don't want to use them all up. So prosecution didn't want to use one up on my wife. We didn't want to use one up on my wife. So eventually the judge became involved and simply discharged her. Now, can anyone see any good reason why the judge came to that decision to discharge my wife from being a potential juror? Does anyone wish to offer a suggestion? So this was the second interesting thing that happened in my day today. I don't want to do all the talking tonight. We want to encourage someone to do some talking. So why should I do that? Yes.
I'd hazard a guess at either conflict of interest or impartiality.
Very good. Okay, so conflict of interest or impartiality. What if my wife says to that, well, I don't see there's any conflict of interest. I'm not going to do what he says. Just because he's representing, that doesn't mean I'm going to acquit. And impartiality, how dare you say that I won't be impartial? What do you say to that? But good points, Peter. The judge didn't rule on that basis. The judge didn't rule that there would be a conflict. Well, not necessarily, but why else would the judge think that way? And I should say this was done in chambers, so we don't have anything officially on the record, and I'm surmising. But yes, Peter?
I'd still argue the point that she would still have to have some bias.
Yes, I think that's a very good point, taking the prosecution line. That's good. Anyone else?
Depends what kind of morning you two had together, I guess.
Well, might have been two, Josh. Yes, you never know that. Any other suggestions? Discussion of a case outside of court? Yes, exactly. That's a really good point, Laree. It's very common for people to talk about their day, and if we've got a 4-day trial and we're both involved in different capacities, we just can't talk about it. So that's a good point. Look, I think with the law, there's 2 things here. The first is that justice has to be done. And the second, and it's often overlooked, is that justice has to be seen to be done. And how could it possibly be that justice could be seen to be done if my wife was on the panel? Even though I may have done everything right and impartially and properly and down the line, and she may have done everything right as well. If there was an acquittal and it went to an appeal, surely members of the public are entitled to say, well, that just doesn't look right to me. So even though there may not have been anything wrong, it might be seen to be wrong, and that's just as important. Any questions about that? Any comment? It's an objective view thing. Exactly, Josh. Thank you for that. Okay, so that was the second interesting thing that I had for my day. And the third interesting thing was I had a sentence before Judge Clare, and this was in relation to, now I can talk about this because it's on the public record now. This was in relation to a gentleman who had viewed some child pornography. It was only fleeting, and the cases clearly show that imprisonment should be imposed in those circumstances. But I'm very happy to report from his perspective that Judge Clare ordered that he be placed on a good behaviour bond. Now, the reason I mention that is partly because I am skiting, because that's a pretty spectacular result, but a fair result. But partly to come back to that first point, dealing with judicial discretion, that if we have a situation where there must be a term of imprisonment imposed and a person must actually serve jail, it doesn't cater for that multitude of circumstances that inevitably will arise in cases from time to time. All right, any questions about that? Now, does anyone have any questions about the reading or any comments about chapters 8 and 11, which are prescribed for tonight? Any questions or comments? Again, I'm trying not to do all the talking here. All right. Well, let me put this to you. I thought the quote at page 267 of the New Lawyer was absolutely terrific. Now, I hope that page 267 is part of our reading for this week. I think it is. Yes. So legal reasoning, chapter 8, legal reasoning. And the quote is, thinking like a lawyer means keeping a cool and clear head and speaking or behaving rationally when others around you may be panicking or overreacting. I think that's an excellent way to describe what we'd like to achieve as a lawyer. It's not easily done. Emotions become involved, people get tired, people start to become biased and doggedly to the point of being silly about it, adopt their own client's attitude. So you've got to keep that cool and clear head. All right. Who wants to tell me about IRAC or MIRAC or SIRAC? IRAC or the variations to that, MIRAC or CIRAC. What's all that about? Anybody wish to make a comment? Does it work? What does it mean? And I hope that you're doing your reading in advance these days. I know it was hard because we had an assignment this week. Yes, Catherine.
Definitely a useful way to work on an assignment, and I think I found it quite helpful in that respect, that it leads you stage by stage through perhaps responding to legal questions,
Okay.
reasoning, and also gives various ways of doing that within the same kind of concept, if that makes any sense.
Yes, indeed. It helps to provide some structure, doesn't it? So if you've got a mental block, you think, well, let's try the IRAC method and break it down. So it's a good logical way to deal with issues. And that's not just for written work, but it's for your letter writing. It's also for your presentations, maybe through submissions in a court case, etc. So thank you, Catherine. Does anyone wish to argue against the use of IRAC generally in your legal studies? Does anyone think it's silly, inappropriate, inflexible, lacks imagination? Good, because I like it. So I'm pleased that everyone agrees that it's a wonderful way to think about law. So thanks for that, Catherine. So we think about the issue. We think about the rule. We think about how that rule is applied, and we come to a conclusion. In your exam, you will have one question which relates to rewording gobbledygook. I mentioned that in the first lecture. You remember that huge diatribe of nonsense that I went on with, which was reduced to one sentence. Now, in your exam, you'll have that. You won't be able to answer it in one sentence. It'll be 100 words that you need to typically convert 500 words into 100 words. I would recommend that you think about using that type of principle as a way of trying to break it down. It may not suit, and it doesn't suit every circumstance, but it's maybe a way of thinking about things. So when you're reading legislation, when you're reading a case, when you're reading a letter, what you need to do is think about what are the issues here, what are the important issues, what are the rules that apply, how do I apply those, and what conclusion do I come to in relation to it. And you'll see that judges in writing judgments follow that type of reasoning, and you'll see it through in the way they write. So there are some variations. You can put the material facts at the front, the conclusion at the front, and then repeat the conclusion. I actually quite like identifying the material facts at the start. So MIRAC is a really good way to do things and a really good way to think about your legal studies. Any questions? Okay, I'd commend the example in the text, which is excellent in dealing with the CIRAC rules. And you'll see the text there about Kevin and the tort of negligence. And the way in which at page 271, the authors have dealt with those issues in applying the legal rules to the facts and identifying. So have a look at that example in the box at page 270. While shopping for groceries in her local supermarket on a Saturday morning, Catherine sees that avocados are on sale for $1. She decides to cook a Mexican meal and make her own guacamole. She selects an avocado, squeezes it. She's satisfied as to ripeness, puts it in the basket, then proceeds to look for corn chips. Then a minute later, she remembers she's already had 3 avocados at home, so she returns the avocado to the display. As she does, Ross, the store manager, stops her and says you can't return the avocado by law. She is already contractually obliged to purchase. So is Ross correct? Well, if you get a question like that, and that's sort of very typical of a law question, it's also very typical of the type of thing you need to address in practice. People will present you with a whole lot of information, not necessarily in chronological or sequential order, and you have to select what the most important parts of that. So who wants to tell me, if you had to nominate some words, I'm just looking for individual words now, what are the key words that give us some guidance here as to what's important? What are the key words? Anybody wish to offer any suggestions? Or a phrase? I'll take a phrase. If a word's too hard, you can give me a phrase.
Contractually obligated.
Contractually obligated. Well, yes, I've actually underlined those 2 words. That's great. What about the ones coming down the page before we get to that? But that was great. Thank you, Vicky. In terms of the facts.
I was going to say place it in her basket when she actually placed the avocado in her basket.
Yep, I've actually underlined that as well. And what's the significance of placing it in her basket? That she has somehow adopted it. Okay, as opposed to holding it in her hand may or may not be the case, but placing in the basket, there is some degree of adoption of it. So, yep, I underline those words. What else have we got? Any other suggestions?
Well, John, just from what we've learnt in contract law
Mhm.
so far, the fact that she's placed it in her basket is sort of an agreement before the contract because she hasn't made it to the registers yet. So I don't agree that it'd be legally binding as of yet.
Yep, I agree with you. It's and we're not teaching contract law in this, but you're absolutely correct. It's not legally binding. But what we've done is we've skipped to application. We've skipped to the rule and the application. But so you're right, Josh, but I'm still looking more for the material facts.
To squeeze the avocado.
Yep, squeezing the avocado. I did underline that as well. That she selected and then squeezed. That's right. Okay, and I think just shopping. What was that, sorry?
I was going to say that they're on sale, so they're actually for purchase. Whether that has got anything to do with it, like they're not giving them away or anything. There's actually an offer there.
Okay, the fact that they are for sale. The fact that they're on sale doesn't make any difference, but they are for sale. Yep, that's true. All right. So, and then Josh, you're absolutely correct. My assessment is that the store manager is wrong and that she is not contractually obliged. We won't get into contract law, but there's a difference between an invitation to treat, which is the advertisement, listen, hey, this is for sale. That's the invitation to treat. The offer is when the customer comes along and selects something and goes to the checkout and effectively saying, I wish to purchase this item. That's the offer. And when the contract is rung up and the sale is made, that's the acceptance of the offer. So, yep, absolutely right, Josh. Just an invitation to treat. All right. So, in that exercise, all I really wanted to do, no, don't apologise. All I really wanted you to do was identify what are the key points. Now, nobody said that the fact that she wanted to cook a Mexican meal was a significant fact. Nobody said that it was a Saturday morning. That's not material. That she was cooking a meal that night, that she was making guacamole. These are all just red herrings. They don't make any difference at all. The fact that she went to get some corn chips and that she turned around. So you understand that typically you'll see a lot of things which you don't need as part of the presentation to you. Okay, so what was not relevant, Catherine was shopping on a Saturday morning, the avocados were on sale, that she was cooking Mexican meal, that she bought some corn chips, that she returned to the fruit and veg section, and it doesn't matter that she had 3 avocados at home in the fridge. So the legal issue is the handling of the fruit tantamount to an acceptance of the offer, and the answer is no. Okay, how did you go with the legal logic in pages 272 onwards? Anyone have problems with that? And then the deductive logic going through, deductive reasoning, all x's are y, this z is x, therefore this z is y. Did we all follow that? It's not easy, and it can be a bit tricky, particularly when we start talking about inductive reasoning or reasoning by analogy. And that whole series on reverse accident, attacking the person, etc., can be a little bit exhausting. You won't need to worry about all of that too much in practice in real terms, but it is good and useful and examinable to know the theory. Any questions then about legal logic as described in the book, reasoning by analogy, and the common mistakes that are made in reasoning and logic?
John, could you just go over and clarify affirming the consequent, which is one of the errors that gets made?
Yeah, affirming the consequent. All right, I'll need to refresh my memory. So this is common fallacy called converse error. So we have a valid argument since the conclusion follows logically from the premise. All right. Okay, so I guess what it's really saying is this. So this x, so this is x, consequently, this is that. Now that's invalid because there are other scenarios.
Yeah.
And I think that's probably all we can say about it, is that it's true, but it's not true across the board. There are
Right.
other scenarios that will affect it or could be applied in those circumstances. So I hope that provides some answer, Michael.
Yep.
They're a bit tricky.
Yeah.
Any other questions? Comments? You didn't think you'd be studying logic, did you? Have any of you studied logic at university level or school level? I didn't, but it sounds good. Good subject. I'm not getting any nods. No one's. No. All right. Let's move away from that then. You can do that reading for yourself. Legal reasoning and policy. I can leave you to read through that. I don't think it's hard reading for the most part, and a lot of it is, I think, common sense, but really worth stating, and I think the authors have explained it all really well. I do want to draw your attention to page 296, which is attributes of a legal practitioner. All right, so those of you who are doing this course may be doing so as part of an LLB. Others might be doing it as an elective. Those of you doing it as an LLB may or may not want to practice as a lawyer, but we're studying laws, so we're going to be thinking as if we are a lawyer, no matter what the circumstance that you intend to do. So what are the personality traits that characterize a critical disposition? Being inquisitive. All right, that's good. Being inquisitive as a lawyer, you need to be inquisitive. You need to be alert, self-confident without being brash. Open-minded. I think I picked on the paralegals last week or the week before, where I said that they do sometimes become fairly closed-minded. I do conveyancing. I know contract law. This is how it fits in contract law, but they may not be aware of constitutional law or admin law or torts law or criminal law as part of their answer. So you've got to be open-minded to all sorts of things. Flexible, fair-minded, honest, prudent, diligent, and persistent. They're a really good list of attributes for a good lawyer. Okay. Tomorrow, I'm in the Magistrates Court. I'm in the District Court. We've got our trial continuing, and I just received word today that there's a Supreme Court call over at 2 o'clock, and somehow you've got to juggle all that. So try and, in those circumstances, you've got to remain calm. If you do practice in law, you're going to have circumstances where you think, I'm not sure, I don't know how I'm going to cope with this or deal with this. There's so many things flying at me. It's really good to have good habits. We'll talk more about that in later weeks when we talk about self-management skills. And we'll also talk about fitness. So tomorrow afternoon, after doing all that, I'm determined to go swimming and join the squad and try and keep up with the slow ones in squad swimming. So I hope you're all keeping up your exercise and keeping up your sleep as well while you do these studies, because I know there's a lot of work. Any questions or comments about what you're doing, how you're going about your study, how you're keeping up to date? Nothing?
I've got a question. It might be a silly question.
No, there's no silly questions.
I am the world's slowest reader. Is there any tips or anything I can look at to actually just speed up and comprehend what I'm reading? Especially when you're really tired and trying to do it at about 10 o'clock at night.
Yeah, look, I often read textbooks with one of these, and what I do is try to identify the actual words that I need, and if I can identify the words that I need out of a paragraph and reduce it to something much less, it's a great way to ensure that I've read it carefully, but it's also a really good way to revise it later. So one tip, use one of these things and just select the key words, but make sure that when you've completed, what you've highlighted actually reads as a sentence in its own right. Does that make sense? Let's take an example. Have you all got your textbook in front of you? can someone select a passage that they would want to consider? And this might be, I'm really trying to find a way of helping you with that issue, Vicky. So does anyone have, just select something and we'll all have a look at it and we'll try and work out how we might use this to do what I'm saying. Has anyone got
300, creativity in law school and legal practice.
what page was that, Erin?
300.
Page 300. So everyone got turn to page 300. Okay. And which passage do you want us to look at?
Starting at the second paragraph.
Okay. Creativity is just as unlikely, etc.
That's right.
Okay. All right. Well, we've got this. So I want you all to now select in that paragraph the words that you think are the most important. Is this going to help you, Vicky? All right.
Yes.
Great.
Yes.
All right. For those that are watching, hopefully they can, in a Zoom session later, they can join in the same activity. So let's give it 30 seconds or so, or a minute, to just go through that and identify the key words. Okay. How are we going? Another 15 seconds or so. Okay. Does anyone wish to offer a suggestion on how we could just highlight some words in that paragraph so that when we come back and look at it later, we know what it is by reading what we've highlighted? Anyone wish to offer a suggestion?
I would have thought the main idea of that paragraph is that creativity is drummed out of people.
Yes, that's true, but that's paraphrasing rather than, when it's right and it's good, but it's not the exercise that I'm looking for at the moment. And the reason I'm doing this is to try to give Vicky some concrete suggestion in terms of how to read a textbook in law or a case or a statute even. Well, how about I give you my take on it and you can pull it to pieces and tell me how wrong I am. So I've just highlighted these words so it reads this way. Creativity is unlikely to be encouraged in legal practice. In law firms, the tendency to be innovative is well drummed out of people. New lawyers are encouraged to engage in analysis, to focus on finding flaws rather than discovering possibilities. All right. Any comment about that?
Do you think that that you need to include there something about rather than in accordance with precedent, look at and innovate?
Yes,
innovate
absolutely. You could do that. And I think here's the point with it too. As you're reading a paragraph like that, what I think is important may not be what you think is important. But I think what I'd like you to do is make sure that when you highlight, you can read it back by just reading the yellow bits, if you use a yellow one like I do, and understand it. It's a great way to refresh, and in a stressful situation, it'll just give you that key to what it is. So, yeah, that was my take on it, Erin, but I can't argue against what you said. Of course, the problem is, and the common mistakes are, people highlight the whole lot. Well, there's no point then. Or they highlight a few words, but they don't put it into the form of a sentence. So all you're reading is a few words, and then you have to read around it to make sense of it anyway.
I think, John, though, if you're highlighting just a few words, I find just by highlighting a few words and then you go back and make notes,
Yes.
those are the words that you need to incorporate into notes, whether you use dot points or whatever.
Yep.
Is a way of following up on the main parts of that paragraph.
Yeah, look, I think that's great. And a lot of people make notes in the column to the side, or sometimes maybe an asterisk, or just something to bring it to the attention. Yep. So selecting a few words, if that works for you, then that's fine. But I think you've got to find your style and try and be consistent so that it helps you with your reading. Now, one thing that we can glean from this, Vicky, is, I read that paragraph, highlighted it, and that took me, I don't know how long that was spent, probably 3 minutes. Now, that's pretty slow, but it was done carefully. And of course, the speed at which you read is going to vary depending on what you're reading. You need to make that assessment, of course, as to the relative value of the material. And then your speed will follow that. I mean, a lot of speed reading techniques revolve around going, I suppose, from one word to the other and dropping out the different words, the words that are connectors. So going to the substantive words and just reading those and connecting the dots in your own mind. But you've got to be careful with that because sometimes the connector says is, and sometimes the connector says is not, and that can make a big difference. All right, so some suggestions. Erin reads around the topic. That's good. Laurie uses different colours based on the importance of the information. Catherine says the volume of reading generally is the issue, and that's right. If you're really going slowly, you'll never get through it, so you have to move quickly. Sometimes I think it's a good idea to kind of let your mind allow the information to flow over your head in the first reading, probably a quick reading, just to get the general feel of it, the flow of it, and then go back a second reading in a more detailed way. I think that's a good way to do it as well. All right, so Vicky, I think everyone is very appreciative of your question because the feedback seems to be that everyone is struggling with the same issue. And, you'll still have that for a long time. Reading and trying to retain information after a long day, that's always difficult as well. That's why we try and keep up your sport for those of you that like Pilates or yoga or walking or running, if you're keen enough. All right.
Thank you. Great help. Thank you.
Okay, thanks, Vicky. All right, so that was page 300. Now, I think let's go to chapter 11, and that was the second part of what we're doing tonight, I think. While I'm getting there, were there any questions about chapter 11, which is being realistic? There's quite a lot of theory in this. I would suggest that you read carefully the material on judicial activism, because that deals with one of the pet topics of separation of powers and the role of judges in making law, and that intrusion through the Mabo case in lawmaking in Australia. The advantages and disadvantages, why people say judicial activism is no good, why people say it is good. I can tell you that the exam is written, and I wouldn't worry too much about the pure legal theories in relation to liberal theories. So a lot of that material on critical legal studies postmodernism and the law, postmodern theory. You probably won't get too much. I'd definitely have a look at feminism and the law. I would look at critical race theory as well. And a really good article, which is extracted, which is an extract from the Australian in 2008. This is on pages 401 and 402. I'd have a look at that. And I just love the way in which the author, Janet Albrechtsen, has written this. I accuse some judges of naked, unvarnished judicial activism. She then goes on to talk about Mabo's decision. And then over the page, the final paragraph, the author says, that's why in defining judicial activism, judges need to take account of what a substantial majority think about its decision-making. To summarise, for judicial lawmaking to be acceptable, I submit it must be so obvious that a substantial majority of Australians regard the change as incremental or reasonable that it goes without saying. Okay, so, you know, it's all very well for lawyers and people like me to be critical of Parliament introducing mandatory sentencing, but we have to accept it goes the other way. So if judges start making the law, then I think commentators are entitled to be critical of that as well. All right, so that's a really quick wrap up of chapter 11. Were there any questions? Does anyone wish to make any comment about legal theory that I've glossed over so loosely?
John, just getting back to judicial activism, would you like to take a guess at who you would think in our time is basically has been quite good at taking up the cause of things in the law that don't sit quite well, or things that do?
Yes, in the English law, Judge Denning has always been my favourite judge, and you'll see there's some material from Denning in my sample document. So he's not only very good in terms of providing a model on how you might consider writing your material using those short, sharp sentences and introducing the background before getting into the legal commentary, but also he was very innovative in making law. In the Australian scene, I think from the High Court, Justices Murphy and more recently Justice Kirby would be people that you'd want to have a look at in terms of the way in which they go about modelling new laws and putting a new slant on laws. But that's, again, a bit subjective. Thanks, Erin.
There's a guy in, I think he's in the New South Wales Supreme Court, I could be wrong, or the Federal Court. Is it Spiegelman or Spiegelman?
Spiegelman. Well, there's, I'm just trying to think. I think I've seen material, but I can't place any particular judgment.
From a couple of the judgments I've seen of his, he seems to be quite forth with his comments and things and how he interprets the law.
I think there were some really good judgments in environmental law. No, I haven't got my environmental law book handy in that regard as well. I'll give that some thought, Erin. If I think of one, I'll post it on Moodle or UCrew or both. Thank you. Are there any other comments about people that have come across a judge or a decision of a court which struck you as being particularly innovative? Anyone wish to talk about other legal theories? Moderate formalism, Fuller, Hart, any of those? All right. Well, look, let's move on. And I'm just going to wrap it up now, but I'm going to leave you some homework. I'll post this on Moodle, but I want you to do some legal research. As I said, we can't afford just to leave legal research to the end. So I'd like you to see if you can find section 754 of the Police Powers and Responsibilities Act, which is a Queensland Act. And I want you to find two relevant cases relating to section 754 of the PPRA, as we call it, the Police Powers and Responsibilities Act, and tell me why you think those cases are important. And the second part is check out the Criminal Code of Queensland. First thing is you're going to have to find the Criminal Code of Queensland. And then I want you to have a look and see if you can find section 24 and just select one case. Just the name of it's fine. And finally, I want to see if you can find the Australian Consumer Law. Now it's Commonwealth. And tell me if you can find your way to section 29 and tell me what it's about. Okay. All right. And then, sorry, one final thing. The Fair Trading Act, which is state, section 16. Tell me what that's about. And that follows on from the Australian Consumer Law. Okay, well, I'll post that on Moodle and Ucrew. Please exchange your answers and we'll discuss those findings next week. All right, so we'll wrap it up. Thanks very much for your patience. Any final questions or comments? Nothing on the chat line? All right, well, I'll end the recording now. Thank you.